number 51, Adar Bays versus GeneSYS ID. Counsel?
Good afternoon. May it please the court, my name is Marjorie Santelli. I'm going to represent GeneSYS ID. I'd like to reserve 5 minutes or 2 minutes for rebuttal.
2 minutes for rebuttal, you may.
The precise issue in this case is whether the conversion option in this case should be considered interest for the usury statute. We say this is an unreserved yes. The key to understanding the conversion option just has to do with understanding the option itself. If you look at a typical stock option, it's the right to buy a share of stock for a particular price for a particular period of time. So if your strike price is $2 and the stock is $1, your option isn't worth anything. It's out of the money. But if the stock goes up to, say, $10, now your option is worth a lot. It's worth $8 because it's in the money by $8. If you look at this fixed discount option, it's much different because there's no fixed price. The price is just pegged at 45% below the fair market value.
So, counsel, if I can stop you over here, sorry, right here,
Yeah.
for a second. If this were instead a fixed price option, would it be valued as interest or no?
A lot less likely. I mean, I think it would depend on if it was in the money at the time it was transferred. You know, there was another case, I think
When you say time transfer, do you mean when the note
when it was given to the...
when the note was issued?
Yes, right. But I mean, it's a much harder question and a much different question.
But typically they're not in the money when the note is issued, right? Or at least there's a period of time before they can be converted.
For a typical stock option, but not for these.
Right. I'm trying to move away from this for a second to ask you
Okay.
about fixed price options.
Yeah. I mean, I think it's not that clear because, you know, you looked at this biometrics case and where they were given valuable options that were well into the money at the time they were issued. And so the court remanded to get a valuation on those options. I mean, any fixed price option, there can be a valuation. If you look at the federal court case in Flow, there seemed to be some kind of question as to the valuation there.
Counsel, here. I have a little trouble with the phrasing of the question from the circuit, and I don't mean this as a criticism, obviously. I think, though, it's a bit difficult for us to answer the way it's phrased, because the way I look at it, we have a test, or a general test for usury, and we have a burden placed on the party raising it. And this seems to ask us, as a matter of yes or no, whether this particular setup in every case is going to be per se usury.
Well, if the question is it interest? So you're looking at...
Yeah, but once we say yes to that, is there any way that it's not a usurious contract?
Well, I mean, you have to look at the value of the conversion discount. I mean, if the discount is, you know...
Yes, but let's say it's anything over 25%.
I mean, you're looking at basic stock option valuation.
No, but my question, though, if it's anything over than 25%, the answer is, once I say that, once I put in as my defense, my burden is met. Once I show you on a piece of paper that I have a discounted option at 25% or more, I win.
Yeah, I mean, unless it's not a publicly traded stock or something, I mean, you might be able to...
But wouldn't it, let me ask this, because I think Judge Garcia's question seems to go to the heart of this. Is it the calculation that takes it over 25%, or is it the consistency of the mathematical results that always occur? If you have a 35% reduction, it always results, it always yields a fixed amount of 54% at the end of the conversion. And the only variable is how much of the principal would be converted to stock. So if it was 20%, it would be lower than 54%. But that ratio always holds true. Isn't that the core of your analysis here?
Yes, I mean, you're talking about what.
So the fixed ratio then is what establishes whether or not it goes over that 25%. So the question is, because it's not going to always take it over, different interest rates below that wouldn't do that, right?
Right, and it would depend on what your stated interest rate is too, if there is a stated one.
But the ratio would always remain the same.
It would, and it's.
And so the question then would always be, back to what Judge Garcia said, is it just that 25% threshold? If it takes it over that, bingo, that's it?
I mean, that's the law, you know, I mean.
No,
if this-
that's not my question to you.
Okay.
We'll figure out what the law is. We're trying to figure that out here today, but my question to you is that what you're arguing as the core of your analysis?
We're basically saying that the conversion discount is so clearly conveys value that that you can't ignore it as usury. It's, you know, for every $100 that the lender exchanges, $100 of debt exchanges, he gets paid with $154 worth of stock. I don't know how you can.
But what you're saying, though, to me, is more than that. You're saying all the elements of a criminal usury case are met when you agree to give an option on a stock that trades over the counter at a certain time in the future at a fixed discount, but you don't take into account the market, the nature of this stock trading, nothing. All you have to do to come in and get out of these contracts that you have are come in and say, look, we agreed to a more than 25% discount on a very sparsely traded stock, and that's criminal usury and contract void. That's it.
I think if you had a stock that was so sparsely traded that you didn't want to use fair market value, then that might be something for the courts
But then how
to.
do we answer this question just as a blanket yes? Isn't it really depend on whether or not you as the debtor has come into the courtroom to try to get out from performance of this contract and met your very heavy burden to show that this was criminally usurious?
Yeah, I mean, the certified question seems a little bit narrower to me, but we are talking about if the intent to charge in excess of 25% is in the four corners of the contract. I mean, that's what we're looking
But
at
isn't
here.
that really the question?
Yes.
And so the question really is, was that the intent? And I think a lot more perhaps goes into that because, well, if it was Apple, or if you're paying someone off in euros, and you're going to discount the rate for the exchange, but if you're talking about a stock like this, maybe that's a harder thing to show in the particular case. So if we answer the question as posed yes, that never happens. The only thing that happens is any company that agrees to a stock option, no matter how their stock fluctuates, no matter what the situation was when they entered the contract, comes in and says, we enter into agreement to sell our equity at a more than 25% discount, we don't have to perform.
Well, but you have to remember that each of the events that you claim are going to possibly devalue this interest are events of default. You know,
No, they're
it's-
not. No, they're not. What if your stock just doesn't really trade? What if nobody wants, it's an over-the-counter stock, right? There's no
Yes.
market for it. There's not NASDAQ, it's not Apple.
Well-
So you don't have to default. What if nobody's really buying it?
Well, if you look at the contract, most of the contracts say, you know, if there's no bid, if you lose the bid, if there is actually nobody buying it, then that's an incident of default. So that the lender can accelerate payment and sue to collect whatever amount. But you also have to look at the ability to convert in tranches. Maybe it is a thinly traded stock.
But I guess my point is, why can't you all think about that when you're entering this contract and say, look, these are all risks by the nature of a micro-cap stock like this, which is why you're not in the regular credit market. So an 8% rate isn't going to get you this contract. There has to be some type of upside on an equity investment, but the equity doesn't really trade. It trades in this other kind of market, and there's a lot about the over-the-counter market out there. So can you really say in that situation, in every case, in every company, when you come in and you agree to this type of discount, that's always going to be usury?
I still maintain that, I mean, if you look at the record of these cases, they typically don't have any trouble converting. But if you did have a particular stock that you think that couldn't be valued at the fair market value because of whatever problem, inability to trade it, whatever, then the court could deviate from fair market value in that case.
But aren't you putting then the burden on the lender? Isn't it your burden to come in and say it is? That this was valued at the time in a certain way?
But I think that if you, on the four corners of the contract, you're charging in excess of 25% interest
Well, that's
using the conversion
question, right?
discount.
But the argument goes to, the way I understand it, a Union Capital case kind of talked to some of these issues, and the defendant raises a strong response to that analysis, calling that analysis fundamental error. I think that's why it goes back to the first question I asked you. Is this conversion rate a fixed component of it that is, of this contract that will consistently result in exceeding the criminal usury rate, and it's irrelevant to the potential profit or loss that you receive on that the 54% per $100 profit is criminally usurious on its face.
Right.
And that's your argument, isn't it? Your argument is not that it's affected by the potential profit, because though I think it's a reasonable argument, and it's a subtle argument, though, too, because it gets into the problem of expectation damages. And honestly, I have to say, I'm still kind of working my way through this as to how it would always yield a criminal usury rate. Do you know of circumstances where it wouldn't?
No, I mean, like I said, it's only going to be in the outlier case that's not publicly traded or traded by appointment or something that...
So to that point, do you know whether the commonly used methods for valuing options take into account volatility of the underlying asset or trading frequency?
They certainly take into account volatility, but that's not necessarily going to lower its value, because with volatility, that means that it can go down, but it can also go up.
Will it affect the certainty range of the estimates?
I'm not really sure what I mean, the basic intrinsic value of any option is the difference between the strike price and the market price.
Sure.
Beyond that, most of the Black-Scholes type valuations, these equations, they will value the options that are out of the money at the time they were issued to assess, the likelihood. I mean, the old cases like Cleveland v. Loader recognized that the chance to get more than the usurious rate was worth something. Now, those cases were a little bit simpler because the interest rate was already pegged, and so they said, okay, if it's worth more than zero, then it's usurious because we're over the line.
Counsel,
So-
let me move you to the second issue, and if the interest charged on a loan is determined to be criminally usurious, is the contract void?
I think that it is. I think we're looking at an interpretation of the usury statute. There's a reference to the criminal code within the usury statute. And I think ultimately it comes down to, is this a directive to a private party to sue under 190.40? Or is it just a reference to whatever the criminal usury rate is in 190.40 at the time? And so in looking at 190.40, I don't think you can say that parties need to sue under it because it's not a civil statute. There's no indication that private parties can sue under 190.40. Moreover, there's a couple of opinions from this court, I believe Hammelberger and the Brewster case, where there's some language in the opinion that's fairly clear in that they consider it to be, they're incorporating by reference the 25% rate set forth in the criminal code. And ultimately, I think one of the other, Water Chef cases pointed out, no, it was actually Blue Wolf Capital pointed out that if this violates the criminal code, then an affirmative defense means that the contract is unenforceable. So just about any way you look at it, I think you arrive at the contract either being void or just not enforceable.
Thank you, counsel. Counsel?
Good afternoon, Your Honors, and may it please the Court. Kevin Curley of the firm Garson, Siegel, Steinmetz, Fladgate for Respondent Adar Bays, LLC. I'd like to begin by correcting the sleight of hand that has led this Court to ask, what do we do with this option? What do we do with this warrant? This instrument, this convertible note, is not only an option. Appellant asks the Court to treat it as an option and wholly disregard the fact that there is the potential, very good potential, that this loan will be repaid after 1 year with 8% interest, and the option will never be exercised. Now, here's why that's important. If we are to presume that this is an option or a warrant only, and that this will, in fact, be exercised no matter what.
But you did demand part of the loan payment. did
We
you
did,
not?
but a
You did-
usury
You did actually exercise the option. Am I missing something?
No, you're correct, but a usury determination is made at the time of contracting. So we don't look backwards to determine what happened. We have to look at the four corners of the note and determine what may
Well,
happen.
isn't that true for any loan if the interest that's stated is above the number, regardless of whether or not the loan will be paid in time, that you never really receive, the loaner never really receives a usurious amount, doesn't matter.
Correct, but that's a different situation here.
So when Adar Bays entered into this transaction, did they make a projection about a range that it would yield?
Not that I know of. I can say that,
So that your understanding is they just invested the money without having an idea of how much they get back?
I'm sure internally they do. I'm not aware of that number.
Well, wouldn't that internal evaluation be evidence of whether the loan is usurious or not? I mean, suppose it said, as soon as day 180 hits, we're going to convert the first tranche in the sequence, and we expect to get 240% return on our investment.
Possibly, but appellant forecasts it being 54%. I forecast it being 8%. My client could
Yeah, I
forecast
guess,
it being
but
something
the
else.
question there is, that's because you're both sort of arguing what it might be off the face of the contract, but I guess I'm saying, isn't it possible that there exists extrinsic evidence that would allow a valuation firm to say, or another way to look at it would be, okay, you clearly wouldn't be willing to lend them 8% flat, right? Is that a fair assumption?
Yes.
So that this option was worth something to you at the time you entered into it, and the question is, what?
That's not the question for a usury determination.
Why not?
That's a question for a business practice, but for a usury determination, you have to look at the contract. The extrinsic evidence is irrelevant. I do want to just finish that
But don't we
earlier
have-
point I was
I'm
trying to
sorry,
make.
don't we need to know whether the intent was usurious?
We do.
And so if the internal documents say we intend to get 30% interest on this, that's irrelevant?
It's not irrelevant. That would speak to the intent. But I don't think that's any sort of calculus of what actually what the document says, which is the calculus you need to make for a usury
So
determination.
your position is the courts cannot look at anything other than the four corners of the document to determine whether it's usurious?
I believe that that is the case law as it stands, that it must be usurious on the four corners of the note.
Well, I thought the case law was, it's usurious at the time it's entered into.
Correct.
So you would still get to the intent then behind it in a criminal statute, wouldn't you?
Yes, so
It doesn't have to, so Judge Wilson's point is correct then. You are looking at intent. The question is, when do you look at it, right?
correct, yes. I think there's two different, I keep saying the word calculus, but there's the calculus of the interest rate and there's the calculus of intent. Now, what Your Honor asked may impact both, and it may have impacted the decision to enter into the note, but it does not impact the interest rate on the face of the note.
Can I ask you this? Do you dispute the math that 35% discount on $100, the discount rate is applied here will always yield a 54% increase?
That's the sleight of hand that I,
Well, no,
that I was
you
mentioning.
dispute the math. Forget the analytical sleight of hand argument. I understand it. You dispute the math.
I do not dispute the math, but I dispute that that is the reason why the lower courts,
Go ahead, tell me
Decision.
why then.
the speculation that the lower courts discussed is the speculation of whether that option would ever be exercised. We don't know.
So let me just stop you again. So if the discount instead had been a 99.9% discount on the trading price, you would have the same argument?
Correct. We don't know if
you
that
don't
would ever
know
be
if it's converted.
exercised.
Okay.
And if we were to presume that this is always going to be exercised, is always going to yield that 54%, and that the loan would never be repaid in cash, that's no longer a loan. That is strictly a simple warrant, and warrants are not subject to a usury defense. So the presumption will have to cut both ways. If we're going to presume what appellant says, that this will always be converted at a rate of 54%, then we are no longer talking about a loan.
And what
look
if
to
we,
the form and the
assign a
substance.
probability to that instead of assuming one or the other?
If we assumed a probability
probability.
of a combination of the two,
No, a probability of conversion.
still speculative. I think we can say, yes, one conversion took place, the rest was 8%. We can balance the 54% return on the one conversion with the 8% return on the remaining balance. I believe that comes into about 17%. That's permissible. Would $10,000 get it over that $25,000 mark? But we don't know that at the time of contracting, and that is when we need to make this usury determination.
I guess what I'm asking is, at the time of contracting, based on empirical evidence, could an expert, for example, assign a probability to conversion?
Possibly. It would take a lot of speculation and a lot of market predictions.
Well,
No one can predict this penny stock.
why market predictions? Because aren't you indifferent to the market price?
No.
Why not?
So if the market price is trending downward
Yep.
and I execute a conversion,
Yep.
I have my discount. That's fair. We're not disputing that.
And,
But if
and
it's
you
still,
don't care, at the point you execute that conversion, you don't really care what the market price is.
we care if it's still going down
Well-
because we have 3 days to get the shares. And if
That's the
within,
future. You care about what's going to happen to it, but you don't care about what has happened to it, where it's trading at the moment you convert.
Correct. The ratio will always be the
Yep.
same.
Yep.
I apologize. But there are market considerations that would impact whether or not we ever submit that conversion. And I apologize for continuously using we, but I mean my client. If they ever submit the conversion, that's the speculation. There are 4 different interveners, as I will call them, that could prevent these contingencies from happening where this conversion would never take place. Respondent is one of them. They could say, low risk, we want to take the low risk route, we'll take 8%. Appellant is another potential intervener. They could fire their transfer agent. I know counsel mentioned those are all events of default, but those aren't breaches of contract. It's not a breach of contract until that default interest rate of 24% is not paid. So it is meant to protect the conversion right, but a breach such as firing their transfer agent or an event of default such as firing their transfer agent does not result in a 54% interest rate as appellate seeks to impress upon this court. It results in a 24% interest rate, which is perfectly within the scope of New York's usury laws. Intervener number 3 is the SEC. We don't know what the SEC is going to do. The SEC could take a look at appellant's quarterly statement for the year 2016 and find something fishy, put a freeze on their stock or delist their stock completely. The conversion rate will never happen. The last, as I mentioned, is the market itself. As the court was asking, what if no one's buying the stock? Appellant said, well, there's an event of default for that if it goes no bid. Suppose it's somewhere in between. Suppose that there's 1,000 bids per day. In this instance, in the transaction herein, 436,000 shares were converted. Now, a sophisticated investor would look to the average trading volume and foresee that and probably not get themselves into that situation, but that means the conversion will never happen. If it did happen, all of a sudden there was a decrease and there's 1,000 shares being traded a day, and Adar is stuck sitting with 436,000, guess where that stock price is going? Down, 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 way below that 54%. So I could keep going on and on with different circumstances, which would cause this conversion right to never be exercised. But the point is, in a situation where
I'm getting a little confused with this last point you're making,
Oh,
sorry.
sorry.
Because if you've got this discount, and it's not a 1% discount, it's quite a significant discount, aren't you always, even if the price begins to drop, aren't you always making, that's their argument, aren't you always making a certain percentage that's above the percent that's acceptable under our statutes? Aren't you then exceeding what would be the criminally usurious rate?
If I may
mean,
give you a
That's
two-part
what
answer.
I understood their argument to be. Perhaps I've misunderstood. I'll check with them when we get back to them.
There are a few different ways to answer Your Honor's question. The first is I
Because
was...
that's what you've done with the discount. That's the whole point of a discount.
Correct.
That no matter how low this goes, you're getting much more than anyone else would get for the amount that you used to buy.
To an extent, that's correct. I think there are several issues. First, if it is trending downward, I think I had in our papers that on a single day, within 30 days of this transaction, the price dropped 40% in one day.
Yeah,
The discount, while it's a 54% more, the discount is actually 35%.
yeah.
So 40 eats that whole discount up in a single day. We don't know. We have no idea. The second point is...
But really, you're just saying that after you've exercised the conversion option, we're not talking about the note anymore, we're talking about the stock you now hold, there's market risk associated with that stock. It could be because of your conversion, but it could be because of the company's business performance or because of something else.
Correct, but it's that exact risk that disincentivizes potential conversions, which undermines the presumption that appellant wishes this court to make, that the conversions will always happen, and that
Can I-
this discount will always be
Well,
realized.
it might disincentivize a certain amount of conversion, right? I mean, you have to get,
It might.
assuming for one moment we're not talking about the other potential events that Judge Wilson has correctly pointed to. If we're just talking about the effect that the exercise of the option might otherwise have on this price, I think if you've got more to continue to exercise this option on, you're not necessarily looking to get rid of the fatted cow that's feeding you here. Am I misunderstanding?
No, Your Honor's absolutely correct, but the key word to that is it might. And we don't know at the time.
Can I take you on just a second point, because your time's almost up? You argue that this contract shouldn't be void ab initio, it's criminal usury contract. My understanding of the public policy of the state is that a civil usurious loan is over 16% in this situation, and they are void. But you're arguing that a 25% criminal usury rate would not be void. Explain to me the basis for your argument.
So I'll try to quickly go through this. There's a clear hierarchy developed through the statutory framework. 16% is meant to protect the most vulnerable, the individuals, the least sophisticated. 16% and void, they get the most protection. Tier 2, corporations. They're sent outside of the statute to 190/40 to a higher interest rate.
Yeah, but see, your analysis just relies on the penal law. The GOL 5511 sub 1 says all loans with an interest rate greater than that permitted shall be void.
So
go ahead.
5511 specifically references 5501 and specifically does not reference 190/40, right? So if 521 prohibits corporations from asserting usury under 501, then the remedy for that same defense that they are not entitled to assert shouldn't be presumed. What we look
So
at
the
in this-
public policy of the state of New York should say a civil loan that's usurious is void ab initio, but a criminal loan is not.
I think the policy would look to whom the statutes were intended to protect.
I thought the interest rates really operated to do that, but go ahead, tell.
The remedy also operates to do that. I think if you look in 511, at the bottom of that provision, it does make a carve-out for lending institutions, where I'm not saying that Adar Base is a traditional lender
Right.
as envisioned by this statute, but it does create a different remedy. It does create a carve-out that says that interest rate, that's not going to be void. We're just going to either adjust the interest rate or void the usurious aspect of the interest, but that bank is still entitled to principal
Counsel, your
repayment.
time has expired, but Judge Garcia has a last question for you.
Yeah, sorry, I have a math question. $5,000 was the amount you converted, right? It translated into roughly 440,000 shares.
That's correct.
That, again, here's the math question. That to me comes out that to a little more than 1 cent a share, right? 0.0108 or something like that.
That's correct.
The market price then, if you bought 5,000 per share, comes out to 0.016 or something like that? Like, what's the delta, what's the difference between what the market price was set at versus the exercise price?
On the date of
Yeah.
the exercise, I believe the market, I don't believe it, I'm reading it. The market price was .024 versus the conversion price of .011. So it's .013 is the delta.
0.13, okay, thank you.
And if I may add, I know my time is up, if I may add, that delta is not charged to the appellant, as appellant would have you believe. And that argument's in the papers. I did just want to emphasize that.
Thank you, counsel.
Thank you, Your Honors,
Counsel,
for
you
your
have your
time.
2 minutes of rebuttal time.
Yes, I would like to take note that they're ignoring this 20-day low baseline, which is why you get some odd numbers. What they actually got in return for their conversions was far above 54% gain, if you look at the chart in the brief. But
Counsel, let me ask you this. If they had, and I think this goes to something Judge Wilson was asking about, let's say they do have calculations and an analysis from the time of the loan that says, look, based on the market fluctuations and the liquidity in the market, we value this at a 35 to at least % discount of what any trading price pegged in that 10-day period might be. They have that. But we answer this certified question and say, yes, this represents a usurious interest rate. That doesn't matter.
I mean, they only loan to companies that they
No,
think,
but my question, would that matter if they had that information? If we answer the Second Circuit's question, yes.
I'm not really sure, because, you know, you're talking about intent, and intent is looking at the four corners of a document. I mean, I'm certain that that sort of analysis would certainly help, but
But how could it, if you're saying on the face of the document now with this exercise rate discounted at more than 25%?
Yeah.
That's a usurious rate on the face of the document.
it is.
Why would a court look at that then?
I don't think they need to. I mean,
So in any case, then we would assume usurious intent from a discounted rate like this.
I think you could have a presumption, sure.
Doesn't that really then get back to my initial question, which is the burden? If it's not clear on the face of the contract, if that's possible under the scenario, isn't it the debtor's burden to come in and show that that's not true? That, sure, this is possible, but the valuation at the time of the loan was reflected, it wasn't, 35% is usurious? Like, isn't that your burden? And what we're doing by answering the question, yes, my hesitation is here, is we're just shifting the burden then. In a case where it's an illiquid market.
But, I mean, if the stated rate is 26%, I guess you've shifted the burden too. You know, we're looking at something that, they almost always do the conversions. I know that my opponent is saying that this is something we might not exercise, but
I'm not worried so much about the not exercise part. I'm worried more about saying in every case, no matter how speculative the ability to value an asset might be, once you have a
we're talking about the
discount.
fair market value of stock that's publicly traded. I'm not sure where valuing.
But there's different ways of publicly trading, right? Like, NASDAQ's one way to publicly trade and over-the-counter is a very different way to publicly trade, right?
Well, but at the core, you're talking about what a willing buyer and a willing seller agree on. I mean, it's a different market, but it's not a different way of valuing things.
But you need to have a buyer, right?
Yes, and if you don't have a buyer, the company is in default, but.
But
in
doesn't
the-
that go, yeah, but you may have, doesn't that go to the point about how much the stock, especially when you're talking about these types of valuations and these microcaps, how much the stock is going to fluctuate in a day, in an hour?
Yes, but the
Should
stock
I
can
sell
also,
it?
it can also go up in a day, an hour.
Sure,
I mean,
but
because-
that's the problem, right? Like, that's what you're trying to figure out when you enter into the contract. So if he, and I don't know this, but if that company had information showing frequency of these trades, willing buyers and sellers, over-the-counter market, this is the range that I could take a haircut on here on a valuation, on an ability to get any value out of the conversion, and they don't convert all, they convert $5,000. So that party doesn't ever get to show that. This is presumed actually to be a usurious business. Like that, the fact that you're entering into this and you have this discount is criminal usury.
Yes, I mean, it wrecks a lot of companies.
Thank you, counsel.